Hi guys, welcome back to Nairobi Legal. My name is Rogers Githinji, and in this video our focus will be on the law of agency. Now, the law of agency is a very simple topic so long as you understand the simple principles that underlie the 5 ways of establishing an agency relation. And so the goal of this video is for you to be in a position to understand what does an agency relation mean and what are the 5 ways of establishing an agency relation. By the end of the video, I will also provide an overview of the entire topic on the law of agency so that you're in a position to link up the different subtopics together. With this brief introduction, I want us to begin by defining an agency relation. Now, as far as this relationship is concerned, one person called the principal gives authority to another called the agent to act on his behalf, and this creates a contractual relationship to a third party. Now, using the example you can see on your screen, in this case, if John is the principal and Peter is the agent, what we mean here is that John gives authority to Peter to act on his behalf, and whatever transactions Peter enters into with a third party will create a contractual relationship between James and John. So simply put, the agent acts by binding the principal with a third party, meaning that JJ are contractually bound. These two parties, meaning the principal and the third party, will be bound by the actions and the transactions entered into between Peter and James. Simply put, and as a summary, the agency relationship means that there will be a contractual relationship entered into between the agent and the third party, and whatever that entails will be binding on the principal. So I hope you are in a position now to understand what does an agency relation mean. Now, I've already stated that there are 5 ways of establishing an agency relation, and the first one is through an express agreement. So the principal can sit down and come up with an express agreement, and also you need to appreciate as a law student that this agreement could be oral, it could be written, it could be partly written and oral. So what we mean here is that when it comes to writing, the agent, or rather the principal, will give authority through a written document to the agent, stipulating that the agent will act on his behalf. Now, we have something called the power of attorney, and this is simply a document in writing that is made by the principal, giving authority to the agent to act for him on behalf, or rather to act on his behalf in a number of transactions. As a law student, you also need to appreciate that as far as power of attorney is concerned, we have the general power of attorney and we have a special power of attorney. Now, up to this point again, you might wonder, what does a general power of attorney mean? A general power of attorney means that the agent has no specific mandate, meaning that the agent can act in a number of different transactions on behalf of the principal. But when it comes to a special power of attorney, in this case, the principal specifically gives the agent certain things to be done, meaning that should the agent do anything outside that specific mandate, then that agent is acting in his own personal capacity. So I hope you've understood what we mean by creating an agency through an express manner. Express here, what we mean is that a contract will be written, or a contract, or rather an agreement, will be entered into in an oral manner, or a written and oral manner at the same time. Now, moving on to the next way of establishing an agency relationship. This is the implied way of establishing an agency relationship, and what we mean here is that an agency could be created by conduct, by implication, or estoppel. These words mean the same thing. So, just like the word conduct suggests, if the principal holds out a person as his or her agent, then that principal will be bound by the actions and the transactions that agent enters into. So an example here would be that if John allows people to perceive Peter as his agent, then John will be contractually bound. This is in relation to the first example we used as we defined the agency relation. And so if you allow one of your workers or one of your employees to buy goods on your behalf, and the third party come to believe that actually this person acts on your behalf, what we mean here is that you'll be bound by the actions of that person, because you've held out that person to the third parties to come to believe that this person acts on your behalf. So this is what we mean by creating an agency through implication or conduct or estoppel. Now, with that overview of creating an agency by implication, we have another way of creating an agency relationship, and this used to happen at common law. Now, long time ago, during the times of common law, men used to travel a lot. Maybe a man has gone on a journey for 30 days and the wife runs out of food. So what used to happen is that the woman would go to the shop and ask for foodstuffs, and this is what we call necessaries, meaning that things that you need to survive, things that you can't live without. Of course, you can't live without food. So the wife would go get food using the husband's name, and when the man returned, the man had an obligation to pay that bill. So remember, this applied to only necessaries. And the case in question here is the Nanyuki General Stores. But however, this was an exception to that rule because the husband had expressly forbidden the wife from using his name to get commodities using his name from any kind of shop. And so I hope you've understood that we started from the fact that you can establish an agency through an express agreement, through conduct, and now through cohabitation. Before we move into the next key important part of this video, consider subscribing so that you receive notifications every time I post a video on commercial law in Kenya. The fourth way of establishing an agency relation is through necessity. Please pay close attention to this specific slide because it is so common in tests and exams. And so a commercial agency of necessity can be established where the agent is in a situation of an emergency and acts with the aim of protecting the goods of the principal from being destroyed. So here the person is acting out of necessity. Maybe they have been transporting your cabbages for over 1,000 kilometers. The car is broken down and they're unable to reach out to you. And so because they don't want the cabbages to get spoiled, they go ahead to sell these cabbages so that you do not suffer a loss as the principal. And remember, they're going to sell these cabbages without your express authority as the principal. So what comes in picture is a commercial agency of necessity. Also, the point of emphasis for this commercial agency of necessity is that there must be an emergency in the picture. Now, as you can see, I've given you another illustration that you can read so that you understand what does a commercial agency of necessity entail. Now, in this case, if the cabbages have been sold, then that agent has a duty to actually give the profits to the principal, even though there was no express authority from the principal to the agent to go ahead and sell those cabbages. Remember here the main point of emphasis is that the agent is acting to avert the loss, and so they have to remit the profits to the principal. And the other thing is that for this sort of an agency relation to arise, there has to be an emergency situation that prevents delivery of goods. Pay close attention to this way of establishing an agency relation. There has to be an emergency that makes it impossible for the agent to either communicate with the principal, and also they may be acting as a result of trying to protect the principal's goods from getting destroyed. And so this is still an emphasis that for a commercial agency of necessity to arise, there has to be a situation of an emergency aimed at averting a loss. And remember that whatever money that the agent makes in this situation, that money has to be given to the principal. And so with that, again, explanation as far as agency of necessity is concerned, the other key way of establishing an agency a relationship is through ratification. You can also pay close attention to this. And for ratification to arise, the principle must be in existence and the transaction must be lawful. Now, you might wonder, what does it mean for an agency by ratification to arise? Using an example here, if Bahati has undertaken some transactions without the principal's instructions, in this case the principal is Donald, and Donald goes ahead to adopt these transactions, an agency by ratification arises. You see, Bahati acted without the express authority of the principal, but eventually the principal has adopted these transactions. So, meaning that the principal cannot go against Bahati's transactions in future because they have benefited from the transactions and they have ratified them, meaning they have accepted the transactions. So this is what an agency by ratification entails. But remember, the principal must be in existence and the transaction must be a lawful transaction. This is a key part of this discussion that you must remember. Just to emphasize agency by ratification, please remember to watch out for facts that might say that someone entered into a transaction on behalf of a company that was not in existence. Remember, the conditions we've put for agency by ratification are that the principal must be in existence and the transaction must be a lawful transaction. And so the principal can also be a company. Remember, we have natural and artificial persons, and natural persons are human beings and artificial persons are companies. So if facts say that the company was not in existence, that takes you back to the conditions that must be fulfilled for ratification to arise. So watch out for facts that might say that the company had not been in existence, because the implication of this is that if a company is also still in the process of being formed, it does not exist in the eyes of the law. So when you're reading ratification, watch out for simple details. Remember, the conditions are that the principal must be in existence and the transaction must be lawful. So if a person enters into a transaction on behalf of a company that has not yet been established according to the law, then the agency by ratification does not arise on behalf of that company, which in this case will be the principal. This is still an explanation of what ratification means, and you can have a look at it. This slide is an overview of the 5 ways of creating an agency relationship that we've already discussed, and my emphasis was on agency of necessity and ratification. Remember that when we come to an agency of necessity, there has to be an emergency situation, meaning that the agent acts out of necessity to avert a loss. I gave you an example of the fact that if someone has been transporting cabbages for over 1,000 kilometers and the car breaks down and the person has no way of communicating to the agent, and the person knows that it will take about 7 days for this car to be fixed, that person can go ahead and sell the cabbages without the express authority of the principal, and therefore in this case an agency of necessity will arise. Remember here that the person is not acting with the express authority of the principal, but the profits that the agent gets out of the sale of these cabbages must be given to the principal. The other key way of establishing an agency relationship we talked about was ratification. And remember the 2 conditions for an agency by ratification to arise. Number 1, the principal must be in existence and the transaction must be lawful. And also I emphasize that if a principal happens to be a company and that company is in the process of being formed or it doesn't exist, then that goes against the 2 conditions that must be fulfilled for ratification to hold. Remember to watch out for such simple details. Having understood the summary of the 5 ways of creating an agency relationship, this slide is an overview of the entire topic of agency, and as you can see from your screen, the first pointer talks about how an agency relationship can be created. You can please have a look at this so that you understand. And number 2, the slide of course goes ahead to show the elements that are not required to create an agency relationship, and you know that in this case you may either have an agreement or not even have one. Then the duties of the agent to the principal. Remember, the duties of the agent to the principal include the duty to obey the instructions of the principal, the duty of care, and the duty to provide information. The other key thing that you can pay close attention to are the remedies in the event of a breach of the duties as stated under number 3. And the remedies could be that the principal can recover damages for the breach caused. They can also be able to get the profits earned by the agent in that particular transaction, and they can also rescind or cancel a transaction entered into by the agent. So these are some of the remedies in the event of a breach of duties to be done by the agent. Now, lastly, again, you can go through point number 5, which are the duties of the principal to the agent, and then how the agent relationship can be terminated. So this is a key slide that you can read through for yourself to get an overview of the entire agency relationship. Remember, we started by defining the agency relationship. We talked about the 5 ways of establishing an agency relationship, and I put emphasis on agency arising out of necessity and ratification. And now this is an overview of the duties and the obligations, the remedies as far as the agency relationship is concerned. Thank you for watching, and remember to subscribe.